So welcome everyone. Thanks for coming. So this week we're really excited to introduce John Goldberg and Ben Zipursky, whom many of you probably already know. Professor Goldberg is the Carter Professor of General Jurisprudence at Harvard Law School, and Professor Zipursky is professor at Fordham University Law School, where he holds the James Quinn Chair in Legal Ethics. Both separately and together, Professors Goldberg and Zipursky have written too many articles to count on tort law theory, private law theory, political theory, legal philosophy. They also co-author a very influential casebook in tort law, which holds a special place in my heart as probably the most influential thing I read when I was a law student. Professors Goldberg and Zipursky are the two most cited tort law scholars in the United States. And they recently published their most comprehensive expression of their novel account of tort law, which places wrongs and recourse at its center. The book is titled Recognizing Wrongs, and it was published in 2020 by Harvard University Press. Today, they join us to discuss their novel theory and the ways that it interacts with insurance and insurance law. And before I hold it over to them or hand it over to them, I'm just going to plug next week's or the next section. 2 weeks from now, we'll be hosting Daniel Sullivan and Seth Schaffler, who are the two lawyers that litigated before the New York Court of Appeals. One of the most watched insurance law cases in recent years is J.P. Morgan versus Vigilant. And among other questions that case presented was the sort of foundational question of insurance law, which is what type of losses are uninsurable as a matter of public policy. So I encourage you to join us for that session as well. With that, I'll hand it over to Professors Goldberg and Zipursky for some opening remarks about their theory and how it works with insurance law. Thanks for coming.
Thank you, Travis. I'm Ben Zipursky, and I'm going to start us off. First, I want to thank the Center and Travis and UConn Law School and my friend Peter Siegelman for inviting John and me today to talk with you, and I look forward to our discussion. John and I are experts in tort law, but we're not experts in insurance law. We're lawyers and philosophers, but we're not policy analysts or economists. What this means is we don't have much to offer about how to run or regulate insurance markets. In fact, we have nothing to offer on that. It also means we hope that the perspective we are bringing to thinking about how to have a just, fair, and effective system of insurance law might be unusual, might be different. In our book, Recognizing Wrongs, we offer a descriptive or interpretive account of tort law, an account of what tort law is and what it says, and how tort law differs from contract law and criminal law, among other related areas. More generally, we're part of a school of thinkers who believe that the statement, all tort law is just public law in disguise, is not quite right. We believe tort law is a mix of public and private things. In the book and elsewhere, we have criticized a variety of other kinds of theorists, and that's just what I'm going to do for you for a moment before I turn it over to John. And I'm going to try to give you a sense of what our aspiration is about where we fit. Okay, and so when we were in law school, the many judges and scholars thought the right way to understand tort law is as simultaneously being an instrument to reach two goals: deterring people from socially harmful conduct and spreading losses. And then we also knew there were these economic theorists who thought that it's not right to try to understand tort law as this kind of pure, messy, ad hoc system. We should have a systematic economic analysis that explains how it's aimed at efficiency. So those are the two theories. One I'll call kind of informal instrumentalist tort theory, and law and econ are the way I'll name those two. And just as John and I were coming into legal academia in the 90s, a totally different view came onto the scene, which was corrective justice theory, which said all of that is completely wrong. The right way to understand tort law as a system that's just about justice between private parties and restoring justice, correcting wrongs that have happened in the world. That's the way to understand it. Now, these three views are really at war with one another, especially the economists and the corrective justice theorists. So John and I hope to be something different from all of the above. And one way I like to think of it is we actually like what the more informal thinkers were in a certain way. We think tort law is very messy. We don't think it's all one system. And but we don't think it's just about cost spreading and deterring. Moreover, we think you're never going to understand it if you try, like Oliver Wendell Holmes Jr. did, to shear all of the moral sounding language out of tort law. If you try to get rights, wrongs, and duties out so you can see things clearly, you will end up actually not seeing things clearly. So our goal is to be like, in a sense, old-fashioned law professors in dealing seriously with doctrine. But we believe the way to deal seriously with doctrine is to take seriously the idea that tort law is about legal wrongs people do to each other, and courts opening their doors to people who want to come in and say, hey, you wrongfully injured me. I get to hold you accountable for that. So that's the theme we stick with. And we actually believe that's the way to be down to earth and understand doctrine. John?
Great. Can everyone hear me okay? Good deal. So again, just let me echo Ben's thanks. We're really delighted to be here. I'll be brief because I want to hear, we both want to hear your questions. But as Ben just said, there's a way in which our sort of fancy theory of tort law is completely unfancy, and almost one might worry it's banal. Because if you look up the word tort in the dictionary, you will discover it means wrong. A tort is a wrong, and that's our claim. Torts are wrongs, but we say they're a special kind of wrong, and that you really need to understand what kind of wrong they are, and what it means to have a system that both defines these wrongs, which you're all familiar with from first-year torts: negligence, trespass, battery, fraud. These are all wrongs. But they're wrongs of a particular kind. They're wrongings of another person. They're injurings of another person, mistreatments of another person, which then in turn generates in the victim the ability to go to court and, as Ben said, if all goes well, if they prove their case, to get redress from the wrongdoer. So there's a wrongs aspect to our theory and a redress aspect to our theory. Now let's try and finally bring around our focus to insurance. One of our central claims is that even though we are insistent that torts really are wrongs, they really are about people behaving in ways they're not supposed to behave, they're legal wrongs. And the law defines wrongs in sometimes, at least in ways differently than wrongs are defined in everyday morality or in moral theory. So again, going back to first-year torts, you may recall that in many respects, the wrongs, the legal wrongs of tort law are defined in a very unforgiving, very strict manner. So a famous example of this is trespass to land. If you intentionally build a fence having every reason to believe it's on your land, but it just turns out you're wrong. The records that you relied on were goofy or whatever, and the fence is on your neighbor's land, you've committed trespass. And when you say, but, I had, every reason to think this was my land, the courts say, yeah, I understand that, you lose, you pay, and the fence will get torn down. Well, that's a pretty strictly or unforgivingly defined wrong. It's still a wrong. This fence shouldn't be there. You shouldn't have put it there. Likewise with negligence, right? Where the objective reasonable person standard says, we don't really care if you did your best. And you just happen to be a little more clumsy than the next person. If you fail to meet the standard, you're held liable, all right? So these are all wrongs, negligence, trespass, etc., but they're sharply defined wrongs and unforgiving wrongs. Well, one thing we think is really important about the insurance system is it's in some instances, not all, it takes the edge off some of the sharpness of these wrongs. Or to put it another way, if you're going to have a system that is a system of wrongs and redress, like our tort law, that defines wrongs in this sharp-edged way, it's a desirable feature of the system to also have something called liability insurance, which allows people to ameliorate or mitigate the risk that sooner or later they're going to commit one of these sharp-edged wrongs. And in fact, it's not just the sharp-edgedness of the wrongs, it's also the fact that liability can often be quite enormous and disproportionate to any plausible understanding of, for example, culpability. So a momentary careless act, which is genuinely careless, that causes massive amount of damage, nobody thinks that the right penalty, if we were in the land of criminal punishment, would be, oh, you goofed while driving, you stopped paying attention for a moment, you owe the state $1 million. But that easily could be what you owe by way of compensatory damages if you have the bad luck of injuring someone when you drive carelessly, even by means of a momentary lapse. And so, again, liability insurance can help hedge against the risk that having a body of law of wrongs that are sharp-edged in these ways and remedies that are quite robust in some ways, it makes tort law fit in overall more comfortably than it would otherwise, to put the point in reverse. If we didn't have liability insurance, I think we'd all be much more uncomfortable about having a law of wrongs and redress that operates on the terms that our tort system does. So that's one important interface between our understanding of tort law as a law of wrongs and redress on the one hand and liability insurance on the other. Second and last point, and then I'll stop. On the redress side of things, we think that in the prototypical case, when a tort plaintiff sues and wins and collects court-ordered damages, what they're getting is redress. They're getting compensation that's a kind of accountability whereby the wrongdoer makes amends of a sort to the victim. Why is redress in the form of money? Does it have to be in the form of money? Why do we think that the right outcome of a tort suit, if that's successful, is plaintiff gets dollars from defendant? We could imagine at least other systems. We could imagine a system which says, plaintiff gets an election of remedies that include taking money or publicly shaming the wrongdoer, or even 10 whacks on the head of the wrongdoer. You could imagine various forms of redress. Our system, I think, for very good reason, has limited victims of wrongs to monetary compensation as the only available form of redress, basically. Injunctions also, we can talk about those. If you're going to limit claimants to monetary redress, it would be nice if there were actually money available for redress. And one of the big problems of the tort system at a theoretical level is if you've got judgment-proof defendants, these lawsuits are all for naught, right? The plaintiff gets nothing at the end of the day other than a piece of paper from the court saying, congratulations, you've been the victim of a tort. And so again, liability insurance can play an important role by helping to make sure that if we're going to have a system of redress that works the way that our tort system does, there'll actually be money available to allow for a meaningful form of redress, which may well exist much less frequently in a world in which there's no liability insurance. So we think there are important synergies between regimes of liability insurance and courts and legislatures being committed to having a body of law that operates the way tort law does. We also think there's some big tensions between the law of wrongs and redress on one hand and tort law on the other, and we're happy to talk about those in the Q&A, but I think I will stop there.
Great, thank you. Very helpful. So I might just kick off with one question that might just help a little bit more in the sort of exposition. I mean, it seems to me that a frequent criticism of the corrective justice theory and other sort of theories of tort law that in the same family is that they are unmoored from reality because they don't recognize the role that insurance plays. This is as you said in the book, it's a kind of horse and buggy theory of tort that's just not modern. And so I imagine it would be helpful for the audience to hear your response to that line of criticism, which I'll just try to, articulate sharply here, which would go something like this. It would say that, that the role of insurance shapes tort law in practice today, both on the front end and on the back end. And so on the front end, it determines who sues whom, because plaintiffs often won't sue a tortfeasor if they know that the tortfeasor is uninsured. And then also it determines from whom they recover. And so if you're sort of in a very simplistic sense, theory of tort law is that a victim is suing the wrongdoer to recover from the wrongdoer because of a wrong that was committed by the wrongdoer, that the influence of insurance just blows that up. And so and I know that your theory may do better than the corrective justice theory on this point, but I think that would be very interesting to hear from you guys about.
Great. Ben, you should answer that. That's a hard one.
Thanks, John. I'll try to answer that. So I guess there are a few different ways to go at it. I mean, first of all, John and I think that in certain respects, the essential role of insurance is, and the commonness, the frequency of people being insolvent or uninsured are actually good reasons for stepping back from what our tort professor taught us when we went to law school. We happened to be in the same tort class at NYU Law School, which is, it's a good reason to be very, very skeptical about whether we should count on tort law to do all the regulatory work that people often think it should do. Tort law is not very well designed as a deterrent system, and it's probably even more poorly designed as a system, as a safety net to help people who have really terrible injuries. Because it's, even apart from the question, which we haven't touched, about how you're going to afford a lawyer and whether there's going to be a market for personal injury lawyers in this particular scenario, even apart from the fact that defense lawyers, are going to be more than up to the task commonly, even apart from those facts, the fact that it's all dependent on a completely different market, which has its own rhyme and reason. It's not obviously disconnected from the rules of tort liability, but it's so heavily dependent on who's solvent and who's insured that if we really care about getting injured people's healthcare costs paid, we are not going to want to see the tort system as essentially a system for doing that, or our system for doing it. So one thing John and I do say is, if we're right about what tort law is in essence about, then we probably need to do a lot more work than others say to get a variety of first party systems in there and a variety of regulatory mechanism in there. So that's sort of on the negative side, or on the side that says, you think we're bad, how about these other guys? But now I need to say something about how we handle this. So I think the way to handle it is to notice two things about our system. One, and this is a big difference between us and the corrective justice theorists, we think what tort law does is empowers people, or purports to give people the legal power to bring a lawsuit. It's not all about making sure that justice gets done, so to speak, in the sense that people get made whole. It is not that well suited to doing that. Now, it doesn't mean that we shouldn't worry about our system, Travis. I think we should, but at least it gets us to ask the right question. Who is it we really think ought to have this power? What stands in the way of their exercising this power to bring a lawsuit and actually to hold somebody accountable? How bad is it that it stands in the way? Maybe it isn't so bad. And if we think it's bad, what should we do to fix it? So at least it focuses us on what we think the right questions are.
Am I supposed to jump in, Travis? I thought you were calling on people.
Go
I'm
for it.
going to jump in. So I have a couple of, or sort of a comment and a question. The comment is you guys both used the judgment proof problem as a kind of justification for your story, and I think I see how it can be, but just as a logical matter, it's also a justification for a lot of other stories. The deterrence theory says, well, people who are judgment proof are not going to be deterred, so we need insurance to either govern their behavior or otherwise, compensate the victims. So I'm not sure that you get to claim exclusive. You can use that as support for your story, but so can a lot of other people for, I think, alternative stories. I guess I was going to ask you a little bit about Tom Baker's not here today, although he's come to some of these things. One of his many very interesting observations, kind of not startling once you think about it, but kind of shocking when I first heard him talk about it, is this idea about blood money and how tort lawyers, plaintiffs' lawyers representing victims, will almost never, except under the most unusual circumstances, go after an insured defendant for more than the amount of the insurance policy. So I wonder what that if you can easily assimilate that to your theory. It seems like it might fit, but I can also see some ways in which it doesn't. And in particular, I might ask you just to comment briefly on the question of whether you think that tort law needs to then say something like everybody has to have insurance, or maybe even nobody may have insurance. I mean, so it's kind of operating in the background, but shouldn't we, as part of your story, then have tort law has to officially acknowledge the presence of insurance because they're so complementary. Maybe I'm just rephrasing Travis's question and I'll shut up now. But anyway, your thoughts would be welcome on that.
All right, I'll try that. I was hoping for an easier question, but alas, dashed. Tom's article, I'm a big fan of that article. I actually think it plays to our plays into our hands at some level, right? Which is, as Ben was saying a moment ago, the corrective justice folks, roughly speaking, I'm sure I'm being too crude, but roughly speaking, say the reason we have tort law is because if a person wrongfully injures another person, they now incur a new or continuing duty to do something else. They had a duty in the first place not to wrongfully injure. Now they have a duty to fix it, to make the problem go away, to make it as if it never happened. And on this view, it's hard to, it makes perfect sense to think of tort damages and tort remedies as being all about making the plaintiff whole, et cetera, in that famous phrase. And our view is related, but it's importantly different because we don't put making whole at the center of our view of what it means to get redress. Rather, we put in, as Ben said, this idea of if you're the victim of a tort, what the legal system gives you is a power to make a certain kind of demand. Well, part of the power you are given, or what it means to be given a power, a legal power in this context, is to give the claimant various forms of discretion, not complete discretion, but a wide range of discretion. This includes not bringing a lawsuit at all, right? It's your power as the plaintiff to decide whether to sue. And there's not great empirical data, but there's pretty good data suggesting that actually lots of people who have been the victims of torts never bother to sue. Now, if they don't sue because they don't know their rights, or it's hard to get a lawyer, or it's too much of a hassle, those are all problems. But if a lot of people aren't suing because they don't want to sue, the system is actually working perfectly, assuming they're well informed and it's voluntary and so on and so forth, because the whole point of the system is to put the power in the hands of the victim. Now I'm finally getting to the point. What I think Tom Baker nicely shows is that a lot of victims exercise this power in a kind of modulated or moderate way. They say things like, and if I'm remembering his article correctly, I haven't read it in a while, but they say things like, look, I'm not out here to ruin the doctor who messed up my procedure and caused me to be hospitalized for 2 weeks, et cetera, et cetera. I want something from the doctor. The doctor wronged me. I want redress. I want accountability. But if you're telling me that my collecting the full amount I'm entitled to under the law means that the doctor has to sell his house and pull his kids out of private school and I don't actually want to do that. And if you're telling me that the insurance coverage will get me this much, and then the doctor will go on with his life, that actually seems about right to me. And that's the victim's call. That's, subject to various constraints. So I think it fits very nicely our story that there's a lot of claimants out there who want and demand and obtain a kind of redress without necessarily being made whole. And under certain conditions, at least the absence of being made whole is not the tort system working dysfunctionally. It's the tort system functioning properly. Relatedly, and then I'll stop, you made a point, Peter, which I think is very important, which is the place of insurance among the synergies between insurance and tort law is what I gather is a pretty common phenomenon that insurers exercise a certain, depending on the case, liability insurers exercise a certain amount of power over their insureds. In terms of telling them, look, we'll give you this policy, we'll give you this coverage, but there's certain things you have to do. And those things that you have to do are often the things that the tort law is requiring them to do, right? So there's a way in which the insurers, because of course, they're just looking at their bottom line, they're not good Samaritans here, but they don't want to pay out. And when do they pay out? They pay out only when somebody commits a tort or other legal wrong. They're actually going to take steps to encourage their insureds not to commit these legal wrongs. So the idea, again, is that it's not that tort law tells us exactly what insurance should look like, nor is it that insurance tells us exactly what tort law should look like. It's that there's reason to think that there's potentially many synergies between the operation of a tort system as we understand it and the operation of insurance markets. Again, with the caveat that there are also some conflicts.
I'll jump into the next one and say that the queue's open for questions from the audience, and if you'd like to get on the queue, you can use the little hand raise function or shoot me a message on the chat. So one thing that we've had several presenters in this workshop talk about is this sort of I don't know, ascendant theory in insurance law land of insurance as regulation. So there was this fantastic article written by John Rappaport a few years ago about how we've struggled with regulating police and police misconduct in every sort of straightforward way, and yet it seems like because the municipalities that employ the police buy liability insurance, that the liability insurers are the ones both best positioned, sort of in an imperfect world, to regulate, and maybe as a matter of fact doing regulation. One could argue that that's not what insurance is for, and that's one line of one response to that, to the sort of proposition that this is a thing that's happening in the world. But I wonder whether the proposition that insurance functions as regulation, or should function as regulation, like how that works in conjunction with your theory of what tort law is and should be. Because I could imagine a response, I think, that would say something like, look, the idea that tort law ought to function straightforwardly as a type of insurance is a misunderstanding of what tort law is. That would be the idea that, like, liability ought to lie with the party that's best able to distribute the loss, or best able to buy insurance that distributes the loss. And that's not what tort law should be. But if tort law operating properly, when mediated through insurance, operates as regulation and risk, then that's fine. And anyway, so question.
Yeah. You want to take it, Ben, or I'm happy to either way.
Oh, well, go ahead, John. You can take it.
All right. It's a little bit what I was saying at the end of my response to Peter. I mean, regulation makes sense, but it's also kind of a misnomer because, again, keep in mind that quietly, in some ways, the tort system is doing a lot of work in how and on what terms the insurers are quote unquote regulating their insureds. In what sense are they regulating them, or when they regulating what are they asking them to do? Well, again, the insurers are not beneficent. They are worried about their bottom line. And when does their bottom line get affected? Well, when they have to pay out claims and defend and so on and so forth. When does that happen? Well, it happens when people have plausible tort claims against their insureds. And so what the insurers are telling their insureds to do when they do this sort of thing is, you need to pay attention to your legal duties. Which duties? Well, in part the duties of tort law, right? So it's regulation of a very particular, or at least sometimes is a regulation of a very, very particular sort, which is a reinforcement or an additional incentive beyond the sort of social norms and moral norms and beyond the threat of liability per se, which is, look, if you really want insurance for this stuff, you're going to have to take your legal obligations seriously, not because, the insurance companies are Immanuel Kant and instructing their insureds on, what they are morally obligated to do, but because they don't want to pay out.
I mean, just to follow up on that, like there's a cynical view, and I think there's some evidence for this, that what ends up happening actually in these situations is that the insurers lobby for reform of the tort law.
Yeah.
In order to diminish their potential liability there, and that I assume that on its face is a kind of perverse interaction from your perspective.
Yeah, I mean, I'll shut up, but that's a very different thing, right? So, of course, the insurers and the American Medical Association and various other repeat player defendants would like, nothing better in the world than to, reduce their tort exposure by changing the substantive rules of tort law. I tell my students, and this is me being cynical just for purposes of teaching, that my understanding of the perfect world for liability insurance companies is everyone believes there's huge liability risk when in fact there is no liability risk. So that everyone buys massive amounts of liability insurance because they're worried about this phantom risk, but it doesn't actually exist. And therefore the insurance companies collect premiums and never pay out. And obviously that's too crude and in a million ways. But so the fact that there are insurers and other actors who are politically powerful and have the political clout at times to change the tort rules in ways that are favorable, I think is a very worrying feature of our political system. And it's part of our story, very much part of our story, that it's important to have a law of wrongs and redress. And if we don't have a law of wrongs and redress because tort reform measures are getting passed that make it not viable for people to bring these claims, et cetera, that's really a big problem.
Can I follow up on that just quickly? I mean, I see Bob has his hand up, so I'll be quick. But I mean, then does your theory pin down what the right tort rules actually are? So when the American Medical Association lobbies for, caps on damages or whatever, harder to prove a claim against a doctor, and they're going to have a story about why that's appropriate, fair, just. They're not going to say it's better for doctors, even though it is, and that's presumably what they mostly want. But they're going to try to make the case for everybody else. So in order to counter that, you need to tell us, well, why should the damages be $2 million instead of being capped at $1 million? Or why should the standard for this kind of thing be set at this level rather than a lower level? And I don't see how any theory is going to tell us that exactly. But do you have can you move beyond like, yeah, it's bad for us that doctors or whatever special interest is pushing to make the rules favor them? What's the right level? As if there was no politics in this at all? Is that somehow that's the baseline?
So I can answer that question. Um, and I'll, you know me reasonably well, Peter, so it won't come as a surprise to you that I'm going to try to talk out of both sides of my mouth. I think that we started by saying we're not social scientists, we're not economists, we're not experts in these things. In fact, both John and I do believe it's important for torts professors and legislators to see what the data say, if there are good data, supporting the claim made by some tort reform groups that the cost of healthcare will really go down if we have caps on medical malpractice verdicts, right? And then to see how much they'll go down, see how much other things could make them go down that wouldn't involve caps. To look at that, that's an important question. I think what John is saying is that if it turned out that they went down so much that people could no longer actually get a lawyer when they're trying to, they really were the victims of malpractice, that would be a problem. How big a problem? Well, this is something that legislators need to make judgments on. We don't have the answer. We can say that there are empirical things we want to know about, and there are value judgments that need to be made. We're not actually going to be able to answer either of those questions, but we are going to be able to give a framework about why it is those questions need to be asked, why, if people have thoughtful, valuable things to say about the answers to them, we should hear, and how it is they should be thought through. So, you know, that's we're not promising to give answers. We're promising to give reasonable and thoughtful frameworks. Part of what bothers us, though, is that anything that could be said about, you know, reducing medical costs is obviously going to outweigh any worries about making life harder for ambulance chasers. You know, that's the wrong way to think about
Good. Bob, yes.
Thanks. So even beyond the notion of caps on tort liability, I wonder whether, as you've thought about this, you've taken another step and thought about those systems where society has decided to take things out of the tort system, entirely things that maybe traditionally have been handled through the tort system, such as injured workers moving into the workers' compensation world, or vaccine bad results moving into sort of vaccine compensation systems, or neurological trauma caused during birth to be taken out and paid for on some sort of scheduled basis. How does that fit into the progression of things that you've theorized regarding tort and how society sort of inserts itself into this decision making?
John, do you want to start answering?
Sure. Yeah, it's an important question. So to be clear, relative to many people who are deeply, deeply skeptical of the tort system and kind of hope it goes away and think that it's like, 16th century technology still being legal technology being applied in the 21st century, we are much less skeptical about tort law. We think it, understood properly, has real value and is an important aspect of our legal system. That said, we are not blindly in love with tort law, and it is not part of our mission to convince the world that we need more tort law or that tort law can never be replaced in part by other systems. And so, again, as Ben suggested earlier, it's partly going to be people asking thoughtfully, and here's the hard part, is appreciating that if you replace tort law, which may well be justified in a certain domain, it's a trade-off. Right? A lot of people think workers' comp was not a trade-off. It was just an unvarnished, better, optimal move to go from tort law to workers' comp for workplace injuries. Well, maybe. I'm not so sure about that, right? Workers' comp is hardly perfect. It's become very sclerotic in its own ways. The payouts stink for a lot of claimants, et cetera, et cetera. So it may be that on balance, we want workers' comp. And part of the reason is there's the operation of the tort system doesn't work very well when the person suing is an employee and the person being sued is an employer, and you're going to lose your job by the time the lawsuit is over. So there's lots of reasons to worry about how tort law is going to operate in the employment system. But if we're going to change, let's understand what we're giving up and what we're getting. And it may be worth the price. But it may not be. And it's a mistake to think, oh, stupid tort system, let's just go immediately to the new and improved and better thing. It might be new and improved and better, and maybe the Vaccine Act is a good example of that. We certainly think that targeted reform. So if it's true that, lawsuits about horrible cases of malpractice that injure newborn children and generate, zillions of dollars in damages and makes OBGYN practice unworkable, if that's really going on, then yes, we need to do something about it. But that's quite different than saying, we should be looking at every opportunity to get rid of the tort system and replace it with either insurance on the one hand or regulation on the other.
I'd like to add a little bit. It's not that I disagree with anything John said, but I just wanted to share that years ago I was invited to New Zealand to give by some big conference of the New Zealand bar. Why they thought it was interesting to invite me, I have no idea, but they did. And I loved it, even apart from the wines I was able to drink when I was there. But I had been raised as a tort scholar in the United States, where if you talk to American law professors about New Zealand, they say, oh, well, they got rid of their tort law. And I sent this to the justices on the New Zealand Supreme Court and the lawyers in their big bar association. They thought it was insane. I mean, from their point of view, it's like telling Americans, because we have workers' compensation, we don't have any tort law any longer. They still have huge numbers of tort suits about all kinds of things, and not just defamation and fraud and other intentional torts, but all kinds of economic law stuff between a variety of different product manufacturers and building companies and so on. So part of what John and I have done by focusing on wrongs, and we've been very open about this since the beginning, is we're pretty skeptical of the legal academy in its efforts over the 20th century to equate tort law with accident law. So almost all of, I think in many cases, the very good ideas about doing something different with than the common law of torts for injuries people have, almost all of those are related to accident law, but there's loads of tort law that isn't accident law. And it's not like it's parts of tort law we don't care about. It's not like we don't care about lawsuits against police departments, or we don't care about defamation, or we don't care about privacy, or we don't care about fraud or securities fraud. And it's not like you folks aren't insuring these people either. So a lot, even though John and I are very open-minded, much more open-minded than many people, for example, who are corrective justice theorists, about these kinds of innovations, and we're proud of being open-minded and thoughtful about it, it doesn't mean we're ready to give up tort law.
One, this might just kind of rewind the conversation a little bit, but it might be interesting also as a way of unpacking some of the details of your theory. So one of the features of insurance that that it sort of imposes on the operation of tort law is that if the tortfeasor is insured, sometimes the insurer will have a subrogated claim against the insured tortfeasor. I mean, I can't really think through it off the top of my head, but it might just be interesting for you guys to talk about how that would fit into the the sort of framework that you're articulating.
Yeah, that's hard. So, I mean, several of these questions, and I know very little about subrogation, so feel free if I say something false or stupid to correct me. But uh, uh, several of these questions are, in a way, at the interface of tort and contract law, which has always been an interesting interface throughout legal, Anglo-American legal history, which is how much do we want the operation of contract law to affect in one way or another the operation of tort law, right? So at some level, right, insurance is a special kind of contract. Liability insurance is a special kind of contract whereby a certain set of liabilities or ultimately responsibilities are handed over to somebody else. So the tortfeasor now doesn't pay out of his pocket or her pocket, but instead the insurance company does. And one concern that people have, as you've mentioned at the outset, is, gee, if you guys are all about accountability for wrongs, but the defendant ends up paying nothing because the liability insurer is going to cover the liability, how is that accountability? In what sense is it accountability to have the liability insurer pay the insured's liability? It seems like the insured just walks away scot-free, whistling, saying, ha ha, I have liability insurance, so I'm not accountable. I can go have another car accident. Well, of course, as you all know, it's not that simple. There are various mechanisms of sort of indirect accountability, including, experience rating, most obviously, and things like that, where it's not there's a kind of reflected or indirect form of accountability, even when the liability insurer sort of pays the bill or pays the main chunk of the bill. And subrogation might be part of that story as well, right? I mean, if it's the case that the tortfeasor ends up, or some other parties end up having to pay some portion here, that all has to be thought of as, to what extent do we want contracts to shape at some level, both the incentives the tort system provides and the back-end accountability it provides.
I see there's an interesting question up here, but I do want to follow up on Travis's question, if you don't mind. I'm going to take it in a completely different direction and sort of touch on another theme that I tried to start our conversation with today. So I'm going to say a few things which many people might regard as sort of formalistic. I don't think the lawyers out there, and many of you are lawyers as opposed to the law students, will find this formalistic. I think you'll just find it law. And one of the things John and I are interested in is being able to talk about the richness of the important legal concepts that are out there. And a lot of tort, including high-end people from the law and econ side, as well as some of the justice people, gloss over very important features of legal doctrine. So here's a biggie. Subrogation has been fantastically important in the history of tort litigation over the last 25 years. Why? Because the smoking litigation, the tobacco litigation, and the state settlements, and a huge amount of the opioid litigation now, and a huge amount in between, none of these would make sense without something that is closely akin to, or in fact, subrogation. So let's just take the smoking case. It was all about the power that state attorney generals had, because they said that as public insurance companies, essentially Medicare, Medicaid, providing the payments for people with cancer and cardiovascular disease for decades, they're incurring billions and billions of dollars of costs. And that's why they are allowed to bring these lawsuits by tens of millions of smokers and smokers' loved ones. That's why they're allowed to bring their products liability lawsuits against these companies, because of a version of federal and state law subrogation, right? And what I thought at the time, and I still think, is these cases have legs only because the plaintiffs' lawyers are maintaining, and the states are maintaining, that they don't have to deal with the individualized defenses against smokers and the individualized litigation over causation, reliance, and fraud, and other things that would have been in the individual cases. But that's not the way subrogation works. If you really understand how subrogation works, it is the individual's claim, but the power to bring it and the funds that come out of it go to the insurance company. And we've only had this generation of transfer of major litigation against big industries whom the public hates and thinks are evil. We've only had that because we've just not looked seriously at how subrogation works. So part of what I'm saying is, people who are torts professors should be willing to look at this doctrine seriously. It doesn't mean I don't think there's value there or more to be said about it. But it's just an example of how the kind of inquiry John and I want to turn to is pretty serious legal inquiry in these cases.
Fascinating. Okay. Sorry, don't want to cut you off.
Well, there was a question in the chat, but I'm happy to go
Follow
to
up on one of our students, Charles, to ask it. If you, Charles, you mind doing it live?
I do not. Thank you. I guess I'm just going to read it because I was kind of thinking as you were speaking out the tort and contract overlap, it's relevant to that. If victims tend only to sue when the tortfeasor has insurance, and then the parties tend to sue only at the policy limits and no higher, if Mr. Baker's blood money concept is applicable there, if you're uniformly capping damages in tort suits, would that not just effectively push cases over to just the insurance contract interpretation? If a suit will only happen in the presence of such a contract and the damages sought would only be governed by the limits of that contract, is insurance law, if it's allowed to get into tort law, is it not just going to take over by a matter of course?
Meaning that nobody will sue anymore, that they'll just be insurance payouts, or that insurance law will have defined what liability is.
Yes, and I'm sure that someone would end up suing because
Right.
undoubtedly an insurer would choose not to pay out. But it seems like
Right.
just having my people call your people, and the discussion is not the wrong anymore; it's the
Right.
policy.
Yeah, well, I defer to the expertise in the room, which is greater than mine, but my sense is, sure, I think sometimes tort law in practice does work that way, where the plaintiff's lawyer sooner or later ends up talking to the defendant's insurer, and they work out a settlement based on a prediction of what's likely to happen. Of course, all of that's parasitic on the tort rules and the tort system and so on and so forth. So we still need to have all the tort rules that determine whether there's any liability at all, et cetera, right? Because that's setting the framework for the settlement discussions. But I think what you're describing is it's not so much that there won't be tort suits, it's that they will pretty quickly settle if everyone's pretty confident that they know how the suit is likely to play out in terms of whether there will or won't be liability, and in terms of if there is liability, what number the jury's likely to come back at. So I do think that, and many people have written about this, that the settlement process is heavily influenced by available insurance funds.
Thank you very much.
Thank you. Good question.
We have 2 minutes. I might just ask one last question. So when it comes to the insurability of things like intentional harms or punitive damages, often it's the case that there's an explicit exclusion in the policy against any coverage for that kind of thing. But sometimes there's not, and then it becomes an interesting kind of legal question of whether those things are uninsurable by their nature. And I wonder whether that rule, to the extent that it's out there, is suggestive of something about the relationship between insurance and tort law, and especially the civil recourse theory of tort law.
John, do you
Right.
want to talk about that?
You should as well. I'll say something brief. Sorry, I've been talking so much, everyone. I don't know what's going on. Too much caffeine.
That's what we brought you
So-
here for. This is
So, I'm not sure. I'm always my back goes up when I hear by its nature, because I don't know what that means. I can see lots of reasons why insurance companies, because of the usual moral hazard, et cetera, why they don't want to insure these things, and why rationally they don't want to insure certain kinds of behavior. But as you all know better than I do, there, as a matter of history, right? If I'm remembering my potted insurance history correctly, liability insurance in pretty much all its forms was once considered immoral and against public policy, because it allowed people to slough off responsibility. And we've gotten over that with respect to accidents and negligence and things like that. Now, there's an interesting question of whether we want to get over that, at least sometimes, with respect to actions that fit the description of intentional torts. And actually, Ben and I were talking about this the other day, and I'm not sure, I don't think we have settled views on this question. I do worry, I think we both worry, that there's certain kinds of wrongs for which you shouldn't be able to kind of contract out of your responsibility in the form of getting liability insurance that gives you, in a sense, too much liberty, practically speaking, to do some pretty horrible things. On the other hand, a lot of what's covered by so-called intentional tort law isn't particularly horrible. So I started with the example of the, trespassing fence. Well, that's an intentional tort at one level. You meant to build the fence there, but it's not intentional in the sense of intending a harm. So we have to think hard about which kinds of intentionality matter for purposes of making us nervous about the presence of liability insurance coverage. Ben, did you want to add something to that?
I don't want to add. I see there's another hand up.
Okay, good.
Question from Peter Kotchenberger.
Thank you. And I'm teaching torts for the first time and using your case book. So this is
Thank you.
probably great. I wanted to follow up on Travis's question in part, because I think the industry or insurers, liability insurers, have, not for philosophical reasons, not because of moral hazard particularly, but have gone well beyond concepts of, excluding intentionally caused harm to exclude increasingly large amounts of harm that, at best would be considered negligent behavior. And that's everything from criminal acts exclusions, which don't differentiate between or necessarily even tie the criminal act to the damages caused, to also where the severity of the injury was completely unintended, and under tort law would, presumably would not make a difference, but under insurance law, it wouldn't traditionally be excluded because it's the harm that was intended rather than the act, where that is being greatly expanded to, exclude more, I think. And I don't know how that plays. So I guess that's my question is, I'm not sure how that plays into, the fact that we're seeing insurers more and more try to, and with some success, not completely exclude a lot of behavior that that's really in the negligence realm, as opposed to intent to harm and the the traditional moral hazards associated with that.
Well, maybe this is too formalistic an answer, but I'm just doing my best. I mean, it seems to me two very different questions, whether states forbid insurers from including certain kinds of categories, and whether insurers choose to make things exclusions. I'm sure in the real world, there are patterns connecting some of these things, but I don't see in theory, at least if consumers are given adequate notice, or if you're dealing with sophisticated consumers, which I guess you're often not,
Right.
any number of things could be excluded from insurance coverage, and presumably, I mean, I know from my automobile insurance or my home insurance, I have a variety of different kinds, or health insurance, I have a variety of different kinds of choices, and I can choose to pay less for certain kinds of policies if they exclude certain things. So that's on the one side. On the other side, I am alarmed by the idea that unforeseeable levels of harm that have nothing to do with different kinds of wrongs are going to be excluded because of their unforeseeability. It seems to me this is one of the great attractions of liability.
That's why you have
insurance.
it.
Right. No, exactly. That's. But I don't think any consumer shops for the best intentional harm exclusion or the most limited intentional harm exclusion, at least not in the personal lines markets, which is where I think the expansion of these exclusions is occurring.
Interesting.
And if they are shopping for that, you'd be pretty worried about them as a person. But so just to follow up on the quickly, because and people should feel free to leave. It's after 5 o'clock, and you guys should feel free to leave if you're getting tired of this. But I mean, so you don't. Your theory does not say that insurance law needs to exclude punitive damage coverage in order to protect tort law, like, because that's kind of the crude view that John was, I think, talking about. Is that was the old line was, yeah, we have to. Tort law wants to hurt these people who have done these bad things by punishing them with punitive damages, and insurance law needs to be like helping us do that by not allowing them to transfer that risk to the insurance company. Does your theory have a crisp thing to say about that, or is it just another empirical kind of question that is a policy question? I didn't mean that sarcastically at all. I just
No.
Yeah. Well, I bet John wants me to answer that because it's about punitive damages. The theory actually does have one crisp thing to say about punitive damages, which is that the best interpretation of punitive damages law that we have today is that it's a hybrid of an old-fashioned conception of punitive damages that really does make sense within a private law model and a more newfangled public law model of punitive damages from the 20th century. And I haven't fully worked this out, but on first cut, it would make sense for the state to not make impermissible what I'm calling the public law conception of punitive damages as essentially a form of a penalty from the private law conception of punitive damages, which is as a more robust form of individual vindication for a person who has been wronged in what the English call a particularly high-handed way, who has been insulted by the wrong. And that's where the historical cases are, where literally, punitive damages was in part put in to stop people from dueling when they called each other terrible things and then turned to the dueling. That is part of the reason for punitive damages. And that really is much more about individual vindication of private right and dignity than it is deputizing the plaintiff to be a kind of deputy private attorney general. So I do think insurability for the private attorney general doesn't make sense. In insurability for the dignitarian, more ample and robust version of vindication for the private party does make sense.
Fascinating. So we're well over time. I imagine we could keep talking for a while, but I want to release everyone, and so. But please allow me to thank you both on behalf of everyone who attended for coming. This is fascinating. We're really grateful for you showing up and sharing your work with us, and we hope to see you as participants in future sessions. And you're definitely very much invited and encouraged to come. Thanks again.
Great. Thank you for the opportunity and for all your great questions.
Yeah,
See you guys.
Thank you
Thanks,
so
both of
much. We've learned a lot.
Okay. See ya. Bye.
Take care.
Bye.